I've litigated hundreds of digital transformation failures in courts across the country. The last thing you want is for your digital transformation to end up in court. What can you expect and what you are getting yourself into? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. Over the last 20 years, I've drafted and negotiated hundreds of technology-related contracts and litigated digital transformations in courts and arbitration panels across the country. I think it goes without saying that your money is better spent getting the system to work than it is litigating against an ERP software vendor. The reality is that these projects fail at a spectacular rate. Depending on the survey and depending how you measure failure, 75 to 85% of all digital transformations end up in failure. Right now, I have about 3 to 5 active cases. One of them is about to settle, and the other one we're about to file, all in the ERP failure space. Primarily representing customers that have essentially been victimized by oversold software, unrealistic expectations, and aggressive sales tactics. What can you expect if you're going to go down the path of litigation? Well, I think you have to have an objective reason to sue. And what I mean by that is you can't sue because the implementation took longer than you expected, the implementation was more complicated than you expected it to be, or you failed to realize all of your expected business benefits. I mean, that's kind of par for the course in these types of projects, and that's typically not a good basis for a lawsuit. There really needs to be some sort of objective failure of functionality. There needs to be some sort of fraud in the sales process, some sort of negligent misrepresentation by the salespeople with respect to what they said that software could do, the functionality that it contained, or there's got to be some objective breach of a contractual obligation. Those are the building blocks of a successful lawsuit against an ERP vendor. If you are going to claim that critical functionality is missing, or that the software does not meet your business requirements, it is imperative upon you, if you're going to go down the litigation route, to have documented what that functionality is, to have documented what your business requirements are, and to have communicated that to the vendor and to get an affirmative response from them that, the software can actually do this. The software contains this functionality. The software can meet those business requirements. If you're going to litigate, you really have to have a reason to litigate. And what I mean by that really is it's not enough to have an objective failure, under which you can bring these allegations. What's the end goal in mind? Why are you suing? Have you been damaged? Have you lost money? What is the amount of money that you have been damaged by? Is it the amount of money that you've spent on the software? Is it the amount of money that you spent on the integration of that software, the customization or modification of that software? Is it a combination of the two? What are you looking for, right? I mean, are you looking for a refund? Are you looking for that software vendor to cover the cost of a replacement system? Are you looking for credits? Are you looking for free services? Those types of goals or end goals, you really need to think about what you want to get out of this lawsuit and what success looks like for you, because then I think your legal team can start drafting the legal documents and positioning the lawsuit in a way that is going to make those goals a reality for you. And I think some of those things are easier to achieve than others, depending on the contractual framework that we're dealing with. If you've got an aggressive, unnegotiated software contract that provides for minimal remedies, getting all your money back and getting the cost of cover back is going to be incredibly difficult. And in that situation, I mean, maybe you're looking for a mutual walkaway, maybe you're looking for free services, credits, if there's going to be an ongoing relationship. That may not be a viable option, but you really got to think about why are you doing this? What do you want to get out of the process? What does success look like for you? And you want to do that at the front end, certainly not in the middle of the lawsuit or at the back end when you're trying to figure out what the parameters of a settlement are going to be. The other takeaway from these lawsuits really is, litigation is expensive. It is going to be more expensive than you expect, probably by multiples. It is going to take much longer than you expect for it to take. I mean, I think I've got clients, that feel emboldened. They feel like they've got the high moral ground. And I think that's all well and good, but a lot of times that doesn't really matter, right? I mean, what they want to do is send an aggressive demand letter, get the software vendor on their heels, and then try to negotiate some sort of a settlement. And while that can happen, if you're going to be litigating against somebody like Oracle, SAP, Infor, any of these big, huge software vendors, you've got to be prepared to go the distance. And unfortunately, that means it's going to take time and it's going to take money. And you don't sue somebody like SAP or Oracle and not be ready to deal with the consequences of filing that lawsuit. It's going to be complicated. It's going to be expensive. We're going to have to hire experts. We're going to need to hire ESI vendors to extract electronically stored information, and all of those multiply the costs beyond what you can reasonably imagine sometimes. And you've got to be committed to the lawsuit, and you've got to be ready to go for the long haul. So look, in summary, litigation is going to be expensive. It's going to take longer than you think it's going to take. You're going to have to invest time and money into the process. And ultimately, and this is what I tell almost every one of my clients when they come to me wanting to sue an ERP vendor or an integrator, that money is almost always better spent in trying to right-size that project to the extent it's practical and to the extent you can do it. Litigation, like I said, is uncertain, it's complicated, and it is going to be incredibly time-consuming, and you've got to be ready to go to the distance. And if you're not ready to do that, unfortunately, I think litigation is probably not going to be a really viable option for you, and that's okay. I mean, maybe you could mediate your dispute, maybe you could arbitrate your dispute. Those can be alternative venues, and sometimes they're much less expensive, particularly in the case of mediation. So you still have options, but the goal really is to get some resolution to that dispute, make you whole, and so so you can move on to the next stage of your business utilizing some sort of a software system that actually works. If you have any questions about anything that we've discussed in this video, please feel free to reach out to us at taftlaw.com. We'd love to talk to you, and we'd love to figure out what your situation is and help you with a path forward. I've litigated hundreds of digital transformation failures. I started over. I mean, that's kind of all I got there. I didn't realize I was at the end.